there anything that you tend to work on with sellers for protections that they look for, whether maybe personally from the directors of the buying business, or is there anything that you see comes up that can give sellers comfort?
Yeah, that's a really good question. I mean, where you've got a sort of, as you say, an established corporate buyer, there's probably a little bit more visibility over where their funding is coming from, so people can get a bit more comfort up front. But I think nonetheless, we would certainly look for some sort of guarantee from a trading company if they then have this complex funding structure where they use new companies for funding and capital adequacy reasons, for example, to put their debt into. Where you've got a more local firm, though, there might not be another company to give a guarantee. So I think the first port would be to certainly look towards the shareholders and directors, and saying, well, what personal security are they able to provide? If they're reluctant to do that, then I think what we would be doing is looking at changing perhaps the payment structure to try and de-risk that and say, well, actually taking a little bit more off the table up front on day one with a shorter deferred to try and reduce the exposure at the back end of the transaction and the risk of potential default. One of the things probably worth touching on is sort of charges. We hear that a lot, where people say, oh, can I get a charge over my company or a charge over the shares? And the answer is yes, technically and legally you can do. And in lots of other sectors, that is probably quite a common security. The difficulty we often have in financial services sector is because of the way that the regulatory capital requirements of these businesses are structured. And by giving charges and guarantees from regulated entities, that can increase the buyer's regulatory capital requirement to in many cases, disproportionate level. So they simply just won't do it. It's not a case that they legally they can do it, they just won't, because it means they have to hold such an additional amount of capital. So what we tend to try and do as well around that is to make sure that if for example payments aren't made on time, restrictive covenants and things lapse, just to again both sharpen the mind in the eyes of the buyer that ultimately it's in their interest to pay and there are some consequences to that, but also there is a sort of a degree of comfort that you're not then restricted from going and redirecting your clients and things like that if ultimately they don't pay you the remainder when due. I have to say though, for what it's worth, out of probably north of about 60 or 70 transactions over the last sort of 7 years or so, we've had one instance where somebody wasn't able to pay on time that we've seen. The payment was ultimately made when they secured new funding, but it's not a widespread problem. As you say, there's certainly a characterization, we see it a lot where people only bank on that first payment, but actually that's not borne out by what we see.